Hello and good evening. I'm Melissa Idris. Welcome to Consider This. This is the show where we want you to consider and then reconsider what you know of the news of the day. New legislative reforms in relation to sexual offences against children and child witnesses have been tabled in Dewan Rakyat. Amendments to the Sexual Offences Against Children Act is meant to tighten the law in line with the current terminology and technology. Amendments were also tabled for the Evidence of Child Witness Act to improve the protection of child witnesses and to ease their testimony. Joining me on the show to better understand how these legal changes might better protect children, we have Karen Lai. She is the Program Director at the Women's Centre for Change, WCC in Penang. Karen, thank you so much for joining me on the show today. I'm hoping we can begin our conversation today by maybe helping us understand a little bit better what's in these amendments, and in particular, the amendment to the Sexual Offences Against Children Act, and why are they urgently needed?
Hi, everyone. Good evening, Melissa. Broadly, there are three key amendments in the Sexual Offences Against Children Act. I'll talk about each and also why they're needed. The first amendment is to replace the term child pornography with child sexual abuse materials. Now, this distinction is important to make so that our laws are not only consistent with international standards, but they also more accurately reflect the exploitative and abusive nature of the offense. So it's very different from adult pornography, for instance, right? So one is to be clear on the terminology. The second key amendment, the introduction of new offenses of sexual performance, including things like live streaming sexual acts, and also sexual extortion. Now, this is particularly important because we know that online violence against children is an emerging and rising threat. Between 2017 and 2021, PDRM reported over 94,000 cases of such offenses. And we really need to understand and anticipate that this is happening to our children. So this is critical. And the third important point, a very positive development, is making compensation for child victims at the discretion of the court. Currently, criminal courts are empowered to award compensation for victims under Section 426 of the Criminal Procedure Code. However, this can only be done at the application of Deputy Public Prosecutors or DPPs. So with this new amendment, the courts will have the automatic power to award the compensation to victims without having to have the DPP apply. So briefly, those are the amendments to SOAC.
So what brought about the need? I'm just wondering, the current gaps in the law, how were they identified? What was the kind of trigger that led to the need for these amendments?
Well, I would like to acknowledge ongoing efforts by the government, in particular YB Datuk Sri Azalina, in constantly engaging with civil society to identify gaps in the law, to identify challenges. And such stakeholder consultations have been widely held, including with the technical support and expertise of UNICEF Malaysia. So there were communications, with different government agencies, with the police, with NGOs, and clearly these new forms of emerging threats were identified, alongside gaps in the law that needed to be addressed. So that's an ongoing process. As we know, law evolves.
So without the amendments, and in particular, say the amendments on sexual performance, sexual live streaming, without those included in the law, did it make it difficult to follow up on cases of sexual performance involving children, sexual online abuse and offences?
Well, that's not to say that there were no existing protections in the law, Melissa. Yeah.
Okay.
There's always the offense of non-physical sexual assault, child grooming, and all that were already in the Act. But with the naming and the specification of these offences, I think it makes it even stronger in terms of protections for children. In terms of what is expressed and what can be acted on by the authorities involved.
Okay, and very quickly, there was also the amendments to the Evidence of Child Witness Act. Can you help us understand the need for to amend that law? I think it's 2007, so it's been many years since the law was first passed.
Absolutely, and we're very happy with this set of amendments as well. Broadly, there are three key areas, and I will talk about each as well as the importance of each. So the first is the Act is now expanded to cover all children under 18. And this is important because the existing act only covered children below 16 years old. And as we know, a child is defined as a person under 18, by the Child Act, other Malaysian laws, as well as the Convention on the Rights of the Child. So this makes it consistent with the other laws. And with this new amendment, all children under 18 will be entitled to protections under the Act, such as special measures to protect them in court, including the use of screens, video live link, and so on. The second key change in this act is a new provision on special hearings to allow pre-recording of the whole of the child's evidence. Now, what do we mean by that? There are generally 3 stages of giving evidence in a trial: examination in chief, cross-examination, and where necessary, re-examination. Currently, the Act allows video recordings by the police to be used as the first stage, evidence in chief. However, under the present law, unamended, the child will need to attend court to do their cross-examination and re-examination. And this is traumatic, having to do that multiple times. So what the amendment does is it allows the child the additional option of pre-recording all 3 stages of giving the evidence: chief, cross, and re. And if implemented effectively, we believe that this will greatly reduce the trauma and the distress experienced by the child. The third amendment, also a very important one, is a restriction on what we call improper questions. Now, this amendment requires the court, it makes it mandatory for the court to prohibit improper questions to child witnesses. Example, questions that are misleading, confusing, humiliating, belittling, and so on. Why is this so critical? We know that the way criminal cross-examinations are done traditionally are grossly unfair to children because kids don't have the same level of understanding and maturity as adults. And it's really one of the most problematic parts of the criminal justice system. Defense counsels who deliberately use confusing sentence structure, or they use language that is beyond the child's comprehension, or leading questions, because children are highly suggestible, right? So, setuju tak, they'll go, yes, sir. So that's very damaging to the child. It ends up intimidating the child, confusing the child, and sadly, they do so at the expense of the truth and justice. So these restrictions by the court, having the court step in to manage that, are very, very important.
Right. Very interesting that this is kind of real-world application. I'm just wondering, where do you see some of the biggest challenges in implementing these amendments, both to the Evidence of a Child Witness Act and also to the Sexual Offences Against Children Act?
I see the challenges at 2 stages. If you look at the criminal justice process, that is the reporting and investigation stage, followed by the prosecution trial stage. So there are challenges in both stages because we're talking about a system as a whole, right? So the first challenge, which is a big one, is actually gathering digital evidence. What do I mean by that? The existing Act, Sexual Offences Against Children Act, has Section 12 on child grooming. Now, we know that such grooming often occurs online. However, in practice, WCC has rarely seen grooming being charged in court. So we're very curious about that. And we're also concerned that such digital evidence is difficult to come by. So we need to address this by increasing the capacity of the police force in investigations. So funding, infrastructure, equipment, knowledge, skills, and human resources, training, and that sort of thing, beefing up the number of personnel involved, that really needs to be done. And secondly, we need to rope in the cooperation of multiple agencies and stakeholders. So it's not only the police, but also the MCMC, the Malaysian Communications and Multimedia Commission, internet service providers, social media platforms, and so on, IT forensics experts. So we need a whole of government and whole of society approach to this. So that's the first part for investigation. The second level of challenge would be at the level of prosecution and courts, and I'm referring specifically to access to justice issues. There is generally a shortage of special courts to hear sexual crimes against children, a shortage of specialized prosecutors looking into these crimes, which require sensitivity and technical knowledge, as well as a shortage of facilities. So for starters, video live link facilities in court really need to be properly maintained because we often hear of breakdowns. So that's an issue. And prosecutors...
Karen, quickly, what is a video live link in court?
A video live link is...
You haven't been
in Of course, yeah. A video live link is a facility that enables a child witness to testify from another room, without having to be present in the same room as the accused person, for example. You know,
and that is often not working. You said.
Well, we hear stories of them not working, and if that happens, then because the equipment is technically complicated, it requires specialized technical maintenance as well, right? So this is again a resource, a budget and funding issue. Yeah. So prosecutors need to ensure also that applications are properly made for these facilities to be used. So they need to communicate, assess the witnesses' needs, make sure that's done. And I wanted to share that WCC studied 35 cases of child sexual crimes, which we supported in the Penang courts between 2018 and August 2022. And we found that in 86% of the cases, there was no application made for the video live link in court for whatever reason, right? There was no application. And in 74% of those cases, only a screen was used. They call it a penghadang, a physical screen, you know. And the screen actually does little to reduce the fear and trauma experienced by the child victim in court. Right? It's really not the best way. Better to use the video live link facilities, and of course, ideally in a special court with specially trained prosecutors and all that. The second area of challenge it's a gap, and we hope to see that redressed, would be the better use of victim impact statements. Now, victim impact statements are allowed under Section 183A of the Criminal Procedure Code. Now, in the same set of cases we studied, in the applicable cases, we found that victim impact statements were only used in under 20% of the cases. So they're really underused. And this needs to change. This needs to increase, especially with the new amendment allowing the courts to award compensation so that the impact on the child can be thoroughly assessed and sentencing as well as compensation be fairly handed down.
Okay. What is a victim impact statement, if I may ask you?
A victim impact statement is a statement that talks about what the impact of the crime has had on the victim. Okay, so it could be an example if the victim had contracted an STD as a result of the sexual abuse, or become pregnant, or had to undergo, humiliation, stigma, loss of income, loss of schooling, that sort of thing. Okay. That's really important. Yeah.
These are really great, very practical amendments needed to bring these laws up to the current digital age. Karen, can I ask you, do you expect any pushback? I mean, do you foresee any challenges in trying to get this law passed, given the fact that it may require an investment of resources and capacity building?
Resource constraints are always going to be a challenge. I believe there have been budgetary injections into the D11, the Women, Children and Sexual Crime Unit of the police force, and still there appears to be a shortage of personnel and technical capacity on the ground. So I think that's one possible area of, I wouldn't call it pushback, but one possible area of challenge as the country faces economic, broader economic constraints and so forth. The other area of challenge is, of course, what defense counsels would say. To that, I would say it's always a question of balancing the rights of the accused against the rights of the victim in an adversarial justice system like ours. Right? So we must make sure that, of course, the rights of the accused are protected. But what we have is a situation where children are particularly vulnerable witnesses, right? And we do not want them. They're the last group that we want unfairly treated or discriminated against in the system. So this is really about balancing those competing interests and ensuring justice is delivered.
Karen, thank you so much for speaking with me today. That's Karen live from the Women's Centre for Change, WCC in Penang. I'm going to take a very quick break here and consider this. We will be back with more. Stay tuned. We'll be right back. Hi, welcome back to Consider This. I'm Melissa Idris. Let's continue our conversation about the efforts to amend and strengthen the Sexual Offences Against Children Act and the Evidence of Child Witness Act. Joining us now, we have Melissa Muhammad Ahir. She is an Access to Justice consultant, co-founder of Kemban Collective. Previously, she was with the Attorney General's Chambers as a federal counsel and deputy public prosecutor for almost 10 years. Melissa, thank you so much for joining me on the show today. The amendments to the Sexual Offences Against Children Act, as we understand it, will include new offences, the sexual performance and sexual extortion part. There's also compensation for child victims at the discretion of the court, and a change in terminology from child pornography to child sexual abuse materials. I'm just wondering, Melissa, do you see these amendments as sufficient? Might there be gaps or shortfalls that aren't addressed in the proposed amendments to the Sexual Offences Against Children Act?
Yes, so largely the amendments are very positive. There's a refinement on language that is already in existing laws. When I say existing laws, it could be the Child Act, it could be the previous bill on the Sexual Offences Against Children Act. And also the penal code itself that applies over everyone, not just children. So the gaps that may need to be addressed is so that this is not targeted for example, genuine relationships, for example, between teenagers. So the very purpose of the law, since it was drafted in 2017, was to target the power imbalance of when children are exploited or abused by those with a very large age gap that had made taken advantage of them, including in those new forms of action that you mentioned, performance or other forms of grooming. So in refining, the gaps that needs to be addressed is on the implementation, on matching to the child in question, and matching up on our investigation technique on how we bring the evidence forward in court. So those are the gaps that needs to be addressed more with regard to implementation.
Okay, all right. I understand that you are with the advocacy group and you have been briefing MPs about the amendments. Can I ask you, Melissa, what has been the feedback? Is there support to the amendments? Is there a clear understanding as to why these amendments are needed? I'm wondering about some of the questions that the MPs may have asked about the amendments.
Yeah, largely a lot of the questions comes from the lack of familiarization on proceedings that are child sensitized, that are centered or tailored to the child in question. So basically the question of how things work. The question of there's a provision on special hearings, for example, and there's a provision on the use of technology, any form of technology, for example. So for this, the questions that the MPs are asking, we do need to educate in terms of how do we have child-friendly courts. So those specific, so we need practice guidelines, we need clear SOPs, and maybe in ways that is not, 70 pages, but instead are accessible in many languages. So any court, any police officer, or any social welfare officer is able to participate in a way that is clear. So also the public, we need public awareness so that parents understand when the children are going through this process. So for all the aspects that I mentioned, I think generally everyone is positive. The police are also seemingly supportive. The courts are supportive. The MPs in the questions are asking for a balance between the right to a fair trial. However, maybe we need to refine more understanding of children's human rights. So you have a right to be believed when you come forward as a child who has been abused. So this needs more mainstreaming. And these are, I think, the way forward for Malaysia, because we need to catch up. Many countries in the Commonwealth have moved forward on this. We are a bit behind, so we need to move forward.
So you mentioned a couple of things there about having child-sensitized ecosystems, right, and particularly child-friendly courts. And this brings me to the amendments for the Evidence of Child Witness Act. There was a part that talked about restrictions on improper questions, and I'm not quite sure what it's like to cross-examine a child, but I'm sure one would have to be sensitive to their vulnerabilities. What do you think, Melissa, are some of the structures and the cultures that need to change to support a successful implementation of some of these amendments? The amendments are wonderful, strengthening protection for children, but what cultures and structures need to change?
Yeah, So when we mention structures or systems within the system, because we have an adversarial system, lawyers ask many types of questions. So within our evidence laws, and not just the ones for children, overall, there's supposed to be a fair and just means of questioning. So that this means you have to follow the evidence. You cannot just ask anything under the sun. You cannot bully the witness. And usually the magistrate and the judge would play a role in enforcing this. And when these new provisions come in, it's now tailored to children and all forms of children. So a child with mental disabilities, for example. So the questioning must match that child. So in culture, there's a lot of stereotyping that comes into the question. So sometimes there's a lot of victim blaming on the basis of gender. A girl and supposedly the victim's behavior, what the victim was wearing. So there's a lot of stereotyping, and this is not evidence. This is general sweeping statements. So this is not supposed to be allowed in, and it's not appropriate. So a lot of the time, it's almost badgering the witness, asking things over and over again, asking things that are not matching that child, of that child's age, of that child's level of trauma. So all this is called secondary victimization, meaning they are re-traumatized due to the questioning. So this is the culture that must change. And I would also like to invite the Bar Council, for example, and other parties like Sohakam to come together so that we can move forward on child-sensitized proceedings. And this is tied to the best evidence rule. Best evidence means a balance between both sides, but it doesn't mean anyone is tortured in court in order to like achieve an acquittal or things like that.
So based on the past few days and weeks since there's been more public awareness about these amendments, are you anticipating any pushback or challenges to passing these amendments for both bills?
Yeah, so for now, the process seems to move forward with a lot of difficult questions, but this is part of the legislative process. It's supposed to be debated. However, we would hope there would be more high quality debate in terms of using the current evidence, current research. So maybe research officers in Parliament can also help. And of course, within the advocacy group, we are here to support all parties that would like to see, especially in terms of human rights, in terms of developments or good practice that all countries have moved forward on, and Malaysia should move forward on. We do have some good achievements or good practices in court, but we need to make it consistent. So from, let's say, Perlis all the way to the end to Sabah, that it applies to all of, let's say, non-urban or rural areas. How many courts do we have? How much facilities that are actually tailored to the child in a way that respects the dignity of the child? So this is where we should be focusing on onwards.
Okay, very quick question in the couple minutes that we have left. Coming back to the issue of compensation, I'm just wondering, why is it important that in this amendment it's included compensation for child victims at the discretion of the courts?
Yeah, so previously it was already in the law for everyone, even adults. When you are a victim of a crime and this has been proven in court, you're supposed to be able to have a right to tell the court your pain and suffering. This is called a victim impact statement. From that impact, your pain and suffering can be seen and you should receive a compensation for it ordered by the court. However, it's not tailored to a child. So now it's tailored more to what the child has gone through. So just quick example, if a child goes to court, the child has been up and down to the courts for, let's say, 2 or 3 years, missed school, didn't receive treatment, didn't go to play therapy, parents have been going back and forth, driving the child. So all of the things, there's even some cases, for example, in Kedah, where the whole family had to move away from their housing area because of the stigma from the case. So all this is part of pain suffering on top of any physical or mental suffering that the child suffered from the crime. So just the experience of the investigation and the court trial. So all this should be calculated and put together for the child and also for future expenses. So how does the child reintegrate back into society? How does the child readjust back to a normal life? So these are the things. So I would say the strongest part of this law is this part on compensation with the current socio-economic situations. This must be given a priority and practiced in all courts by all prosecutors and by all magistrates and judges.
Melissa, thank you so much for speaking with me. That was Melissa Muhammad Ahir from Kemban Collective, wrapping up this episode of Consider This. I'm Melissa Idris, signing off for the evening. Thank you so much for watching and good night.